There is so much data circulating from our photos, videos, social media, GPS, you name it, that 90% of the data that exists is only a few years old. All of this information is referred to as big data, and we use it to better understand the world around us. With this in mind, a research center at the Washington University School of Law is using this big data approach to study the law, in particular, the United States Supreme Court. With the death of Justice Antonin Scalia this election year, renewed public interest in the Supreme Court is giving big data a big push. HEC TV's Nancy Pasternak has the story.
Of the many powers and responsibilities that the Constitution vests in the presidency, few are more consequential than appointing a Supreme Court justice.
While a president serves 4 or 8 years, a United States Supreme Court justice could serve for decades. With the death of Associate Justice Antonin Scalia and President Obama's nomination of Judge Merrick Garland, the U.S. Supreme Court finds itself stuck in the politics of the 2016 election season. Adam Liptak, the New York Times Supreme Court correspondent, explains.
Well, this court in particular seems very aggressive about wanting to insert itself and be the last word in seemingly almost every major issue in American life. The next president is very likely to get to appoint 2, 3, 4 justices, and depending on how the switch is made, it could really alter the texture of American life.
Professor Lee Epstein says this scrutiny of the Supreme Court is nothing new. Dr. Epstein is the co-director of Washington University's Center for Empirical Research in the Law.
If you go back and look at what candidates have said about the Supreme Court for the last couple of decades, they're always contending that they're going to move the court in the right direction, I think, which means the direction that I like.
But is there a way to see which direction the court leans, liberal or conservative? The best way to cut through the rhetoric is with data.
Washington University School of Law is home to the Center for Empirical Research in the Law, referred to as CERL, and is home to the Supreme Court database. The Supreme Court database houses every case decided by the U.S. Supreme Court since 1791, with each case coded on over 250 different variables. The database is not a recent undertaking, but the culmination of decades of work.
So the U.S. Supreme Court database, it really goes back about, I think, 30 years now to a fellow by the name of Harold Spaeth, who is a political scientist and lawyer at Michigan State University. Prior to the database, there were little one-off projects here and there that tried to collect that information, but nothing on the scale that Harold Spaeth proposed. So back in the 80s, the National Science Foundation provided support to build this database, and I was part of that original effort, although it was really Harold spearheading it.
Prior to 2010, the database only existed as a massive flat file coded by a series of 3x5 index cards. Troy DeArmit, the chief technologist at CERL, is the programmer primarily responsible for the massive upgrade.
The first 2 months of the project was just reading Harold's codebook because I had to understand what the Supreme Court database was and what every variable in there meant. We were asked to modernize it for a couple of reasons. One, to make sure that it could be maintained if and when Harold lost interest in keeping it up to date, and also to try to, as was CERL's mission, to catapult it out to more people.
Professor Pauline Kim was first involved with CERL as a School of Law faculty member needing help with her own research. She now serves as co-director of the center. She explains why CERL is uniquely qualified to tackle projects like the Supreme Court database.
So I think one of the biggest changes in the last few years has been the really explosive growth in the amount of data that's available in all kinds of areas of life, but particularly in the legal field. CERL is a center that is focused on leveraging technology and data to try to help us better understand the law and legal institutions. And in doing so, we are aiming to help the law school in its 2 main missions. One is supporting learning about the law by our students, and also the research endeavors of our faculty.
Today, the Supreme Court database is a technical achievement, not just for the scope of the project, but for the analytical tools available to the public.
So you don't have to be a social scientist and know statistical software. You can analyze and learn things about the U.S. Supreme Court right on the website. You want to know whether the Roberts Court rules in favor of the government or defendants in criminal cases, you can find out in a matter of seconds. The database is used not only by scholars in the United States, but also journalists and scholars and journalists all over the world.
One such journalist is Adam Liptak, who now actively helps code the Supreme Court database as decisions are handed down by the High Court throughout the current term.
The database is a fantastic resource, but one frustration we've had with it is that the data are, by newspaper standards, not especially timely. What I've done, which allows us to, in something like real time, see what we can say about the court. And this gave the Times a really early insight in what turned out to be the story of the term that ended in June of 2015, which was that it was trending toward and ultimately became by far the most liberal term of the Roberts Court.
Two of the most significant liberal decisions from the 2015 Supreme Court term were King versus Burwell, confirming the constitutionality of Affordable Care Act subsidies, and Obergefell versus Hodges, that brought marriage equality to all 50 states.
There was a lot to learn about the Roberts Court in particular, not only looking at its work case by case, but also by trying to see what the numbers tell us.
Liptak is on campus teaching a weekend course with Dr. Epstein. The class is about Supreme Court proceedings under the current Chief Justice, John Roberts. The course relies heavily on information learned from the Supreme Court database.
Well, we have now 6 or 7 times done a course on the Roberts Court, which is, to my mind, a very nice combination. It's mostly not about doctrine. It's mostly not about what the cases say. It's mostly about how the court does its work. And the insights that Lee has based on empirical studies and that I have by daily coverage of the court marry very nicely.
It is in this very intersection of big data and academia that the Supreme Court database and Searle exist. The research cannot exist without the data, and the data has no value without a theory to prove. The question here is how to truly understand whether the Supreme Court leans conservative or liberal. Anyone can go see for themselves. It's all in the data. For Innovations, I'm Nancy Pasternak.
The Supreme Court database recently unveiled the third beta release of its legacy dataset, a collection of nearly 20,000 cases dating back to 1791. The public is welcome to visit the website and try the online analysis tools for themselves.